Good evening, everyone, and welcome to the last session uh, for LAWS12061, and congratulations on completing this unit. I would imagine that everyone who's joined tonight's tutorial should be able to easily pass this unit, especially because there was hardly anyone who actually failed in the midterm assessment, and everyone seems to be doing quite well with the quizzes. So let me just congratulate all of you in advance, and especially for your persistence in staying on in our unit, and also because to try to get a law degree requires a lot of effort, requires a lot of patience and persistence, because especially for a lot of those who are mature age students, including me, because I was a mature age student at one time, it's not easy trying to complete a degree with all the other commitments that we usually face, whether it's work commitments or family commitments, and then there are a lot of crises that could happen along the way. So it's not easy, and so I congratulate everyone for staying on in this unit. As I often say, every time you finish a unit, you're getting closer to your goal, perhaps a dream of becoming a solicitor in Australia. And so tonight, as we have our final tutorial, I also wish to express not only my gratitude for staying on and for really being engaging. It's also, it is with some sense of, how do you call that? I would miss the opportunity to have engaged with many of you every week. There were a lot of you, including Nicholas. Hang on, are you getting some background noise? Okay, hang on, give me a second there. Okay, so I've muted everyone now. Okay, very good. So a lot of you were actually there all throughout the term, especially Sarah Goodchild, Sarah Rogers, Gary, Nicholas. They were always there. Who else was there regularly? Sarah Manuel, of course, Lauren, Nancy was always there, Mary Moore, Keith, Mike, yeah, Mercy Sonata was always there, Eva, and Mo, and Jackson, yeah, Ainsley as well, Saturday. So I might have missed others, but I deeply appreciate the fact that you'd always been there, because otherwise it would be quite, it would be quite lonesome if we had a tutorial and there were very few students who showed up. So thank you for that. You don't notice the quiet ones. Yeah, maybe, perhaps. And so Wendy, I'm glad you're here. As you say, you're often at work, and I'm glad you made it tonight. So for a lot of students, this is a very important tutorial, because we're gonna discuss ways by which you could do even better in the final examination. So there will be three things I am hoping to cover tonight. One is we will try to talk about the topics that will be covered in the final examination. Secondly, I would like to go through the key principles that are relevant in answering the final examination questions. And finally, I will try to provide some suggestions on how to do well in a final examination involving case problems, especially if you try to answer using the IRAC format. So those are the three things we'll be doing tonight. Identify the topics to be covered in the final take-home paper, enhance your understanding of key administrative law principles that are relevant to the examination, and then improve your marks by answering case problems well. So before I continue, would there be any questions that anyone may wish to raise, or any comments? So we're good. Okay then, so thank you. So let's proceed. So it's being recorded, very good. I'll make sure to upload the recording straight away after the tutorial ends tonight. Where do we begin? Judicial review element. So what we need to remember is that as far as the final examinations is concerned, we will only be covering the topic on judicial review. So we will not be covering anything about merit review or the administrative appeals tribunal, because we essentially assessed that particular topic during the midterm assessment, and of course that was assessed as well in the course of you having to answer the quizzes. So the focus of the final examinations will mainly be judicial review. Let's see. Okay, so let's go through the 5 judicial review elements. And as I discuss the judicial review elements, what I will also be doing will be to read from Gary. IRAC can be misleading as due to the nature of diversity of argument in administrative law, or am I off the beam? IRAC can be misleading. Gary, would you care to explain that? And then, I'll give my comments. I wonder if Gary's mic might have a problem. So typically, if you look at almost all law schools, not only in Australia, but in New Zealand and even in the US, the use of the IRAC format is actually pretty common when it comes to case law problems. Okay. I can see an issue. So from Gary, sometimes he can see an issue, but others may not agree. Okay, so we're gonna discuss that in a short while. In fact, this, when a student, for example, says that the kind of issue that he identifies is probably different from the issue identified by another student, that just goes to show the importance of identifying the proper legal issue. And that, in fact, again, shows the importance of the IRAC format, which I will go through in a short while and discuss it in detail. So for the moment, bear with me. I will not address the IRAC issue for now, but I will certainly do that towards the end of tonight's tutorial. What I will do in the meantime, thank you though for Gary for raising those concerns. What I will do though in the meantime is that I will discuss the judicial review elements. Now, can I also just remind you guys, because you're all here and there are 33 students now, that I would deeply appreciate if you take the time after the tutorial to do the unit evaluation survey, the Have Your Say survey, especially because the dean expects at least 50% of the students to actually do the survey. Now we need to remember that the survey is anonymous. You will not be identified, and so there's no way of us knowing who said what. But as a way of improving, the delivery of the unit, the school deeply appreciates involvement of students in trying to do the unit survey. It shouldn't take you more than 3 minutes. So I'm hoping that after, from Nicola, so far there are only 33. We need at least 61 to answer the survey. And I would think that there are probably some of you so far who haven't done the survey yet, because it can't be the 33 of you. So from Gary, I gave you 5 stars and everything. Oh yeah, the more, if you see something like that, I'm actually taking down notes. So when I do the marking, the final examination, that will certainly influence me. I'm just a human being. I'm just kidding. Okay, who knows? Okay, thank you. I will remember you, Gary. Yep, Keith, I will also make sure to upload the PowerPoint presentation. So I also wish to emphasize that if we run out of time, I wouldn't mind, extending this particular tutorial. So don't worry, I'll make sure that we cover everything. So for the moment, let me just start going. Judicial review elements. So this is crucial. If we talk of judicial review, there has got to be a legal basis for the jurisdiction of the court to exercise judicial review. Okay? Now, when we think about it, the kind of judicial review that we understand now, particularly about administrative law, is actually of almost of an ancient origin, because as far back as the 1500s, if you think about the history of the United Kingdom, when there was a battle between the monarch and the courts, and the battle between the parliament and the courts, there had always been an attempt on the judiciary to assert its jurisdiction over decisions made by the monarch. So in times past, the monarch was an absolute ruler. So whatever the king said, that was the law. And of course, if that is the case, you can just imagine the abuses and the excesses in the exercise of the powers of the monarch or the king, especially when there has been some delegation of those powers. So in times past, the courts or the common law system through the courts have always asserted their power to review the exercise of the powers of the monarch or the executive, to make sure that everything that the executive did or the monarch did was according to the law. So therefore, at its core, even without talking about the Constitution, even without talking about laws passed by the Parliament, in almost every jurisdiction, courts have always asserted their inherent power to police the exercise of executive powers. So that is the common law jurisdiction. And as we go through judicial review remedy, for example, we will realize that, and we will discuss this a bit in detail in a short while. We talk about common law judicial review remedies as opposed to equitable judicial review remedies. So in other words, when the courts are tried to control or review the exercise of the powers of the executive, it was considered the common law. There was the idea of stare decisis or judicial precedent, in the sense that the common law, it became common because the courts across the UK tried to come up with a common law or a set of rules or laws that would be binding across the kingdom. And of course, if your desire in that primitive legal system is to come up with a common, meaning common to everyone, or a uniform set of laws across the kingdom, it would have to mean that there has to be an attempt of all the courts to try to observe judicial precedents, because otherwise you cannot have a common law. So it tells us, therefore, that if you talk about judicial precedents and stare decisis, it would have to mean that there has to be some rigidity to the rules. You wouldn't allow for a lot of flexibility, because otherwise, if one court would try to be flexible in its understanding of the law, then it would be difficult for the common or the uniform law to evolve. So that's the common law. And so therefore, it is understood that because the courts of Australia, for example, have a historical link to the courts of the UK, it is understood that the courts of Australia wield the power of the common law to review the exercise by the executive of its powers. Again, this is because when Australia was first born, we will recall that it consisted of colonies. And because they were colonies, the colonies that existed then, whether it was Queensland or New South Wales or Tasmania, for example, inherited the legal system that came from the UK. And in that legal system, these courts, again, exercised the common law with the power to control control and review the exercise by the executive of its power. So that's the common law. Now, at the same time, we recall that upon federation, or when the Commonwealth was developed, with what it meant was that the colonies that were then the states, surrendered some of their powers to the Commonwealth or to the Federation. And in doing so, we ended up with the Australian Commonwealth Constitution. The Australian Commonwealth Constitution is quite clear. For example, in Article 75.5, that the High Court has the jurisdiction to issue writs of prohibition, mandamus, and injunction against an officer of the Commonwealth. So there is a constitutional basis for the High Court to exercise judicial review. And because it is based on the Constitution, it's called a constitutional writ. But more importantly, it is not possible, it would be unconstitutional, therefore, for the Commonwealth Parliament to try to remove or oust from the High Court its inherent jurisdiction to issue writs of prohibition, mandamus, or injunction against an officer of the Commonwealth. So we're clear. So that was in 1901, upon the founding of the Commonwealth and based on the Australian Commonwealth Constitution. In 1903, by that time, of course, we had a Commonwealth. The Judiciary Act of 1903, Commonwealth, was enacted by the Commonwealth Parliament then. And under Section 39B of the Judiciary Act, it also provided that the Federal Court of Australia has the power to issue a prohibition, mandamus, or an injunction against an officer of the Commonwealth. So what had happened was that whilst Section 75(5) of the Constitution provided the High Court, granted the High Court its inherent power to, police the exercise by the executive of its powers, at least the officers of the Commonwealth, that same powers were also given to the federal court, which was created by the Commonwealth Parliament. So they're similar. So what it means, therefore, that oftentimes when there is an action for judicial review against an officer of the Commonwealth, it is not always lodged with the High Court, because the High Court will refuse to exercise jurisdiction. Instead, it can be remitted to the Federal Court of Australia, or an applicant can apply straight away with the Federal Court of Australia, because by practice, the High Court will only accept jurisdiction to review in a proper case an application for judicial review when it is of national significance or of national importance. Otherwise, it has to be the Federal Court of Australia, which would have jurisdiction. Now, let me talk first again about another law that was passed by the Commonwealth Parliament. So in 1977, the Administrative Decisions Judicial Review Act of 1977 was passed by the Commonwealth Parliament. So there is a second statute. The first statute was pertaining to judicial review, was Section 39B of the Judiciary Act of 1903. There was a second statute, meaning passed by the Commonwealth Parliament, that again provided for judicial review, and that is the Administrative Decisions Judicial Review Act of 1977 Commonwealth. It is important to clarify the distinction between the two, okay? When you speak of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, remember that the goal of the Commonwealth Parliament was to try to systematize, to try to codify the existing rules about judicial review, and to make it simple, as well as simplify the grounds, be clear about what the grounds are for judicial review, instead of trying to determine what exactly are the grounds for judicial review, and you try to get it from the common law, meaning you try to examine it on the basis of judicial precedents. What the Commonwealth Parliament did through the ADJR Act was to identify the grounds for judicial review, and it also clarified what the powers are of judicial review. Because if we look at the judicial review remedies based on the common law, we would see that there was some rigidity. So, for example, if you talk about certiorari, there is a requirement that any decision of the part of the executive must, for example, be based on an action on the part of the tribunal, and it will have to be based on the face of what appears on the face of the record. So there is some rigidity in the judicial review remedy, and this has been addressed through the ADJR Act because it identifies 4 specific powers of the courts, without limiting the powers of the courts to what might traditionally be called mandamus, prohibition, or injunction. They are broader, and so that's one. The key thing we need to remember as well is that the jurisdiction of the court based on the Administrative Decisions Judicial Review Act can only be triggered when the executive decision, so it has to be an executive decision, is based on an enactment. So that is the key requirement there, as defined by the ADJR Act. So an enactment can include an instrument or a regulation that it arises from an enactment or a law passed by the Commonwealth Parliament, because we recall that it is possible for the Commonwealth Parliament to delegate some of its powers to the executive, what is known as subordinate legislation. So that is permissible, and usually what happens is the Commonwealth Parliament leaves it to the executive to try to provide the details of what the law should be in the form of bylaws and in the form of regulations and other instruments. So the crucial point, therefore, going back to what I was saying, is that judicial review under the ADJR Act can only be triggered, or can only happen if the executive decision is based on an enactment. Okay. Now, what also needs emphasis is that if you were to be the lawyer, okay, if you were to be the lawyer and you have a client who has come to you looking at the possibility of applying for judicial review, your goal would be, if possible, to file an application for judicial review under the ADJR Act, because that's the purpose of the ADJR Act. It's meant to simplify, the system of administrative law and judicial review, and it's meant to codify a lot of the rules that exist in the common law. So that is your goal. But the problem is you can only have recourse to judicial review under the ADJR Act if the executive decision is based on an enactment. So at its core, an enactment is a law passed by the Commonwealth Parliament. The problem, however, is that we know that the executive has what are known as prerogative powers. It has implied powers as well. So it is possible, therefore, that the executive may make a decision not on the basis of a law passed by the Commonwealth Parliament, but on the basis of the exercise of its own powers as the executive, based on its either implied powers of the executive or prerogative powers of the executive. So, for example, the power to enter into the contract, the power of the Minister of Immigration to try to ensure that the territory of Australia is secure from unlawful aliens, or the power of the executive to declare war, the power of the executive to pardon prisoners. These are implied powers of the executive. You do not need the Constitution for that. You don't even need the Commonwealth Parliament to pass a law on that, because these are considered to be implied powers of the executive. So, in any government, for example, if you look at the UK, if you look at New Zealand, where there is no constitution, you will see that you have to ask, where then does the power of the executive come from, if not from the Constitution? But certainly, because there is no Constitution, you would have to assume that the executive has certain powers to execute the laws and to implement the laws passed by the Commonwealth Parliament. So there is an understanding that in a democracy where you have a democratic government and you have at least 3 branches of government, there will always be an executive with certain implied powers. So the point then is that when the executive exercises implied powers, or when the executive exercises what are known as prerogative powers, you cannot have recourse under the ADJR Act. Are we clear about that? Now, the other point then is that if you cannot have recourse under the ADJR Act because the executive decision is not based on an enactment or a law passed by the Commonwealth Parliament, then your application for judicial review can potentially be based on Section 39B of the Judiciary Act of 1903 Commonwealth, or 2, Section 75(5) of the Australian Commonwealth Constitution, if you're trying to apply for judicial review with the High Court. Okay, but as a matter of practice, you do not apply for judicial review with the High Court because it will not entertain the application. Instead, it will remit it to the federal court. So the first port of call in the event that the executive decision is based on the exercise of implied or prerogative powers of the executive would be Section 39B of the Judiciary Act. The problem, however, as we see, is that if you rely on Section 39B of the Judiciary Act, you're limited to only 3 possible remedies: prohibition, mandamus, and injunction. But just bear that in mind as we move on. Okay, so we're clear about that. So now, as to the common law, assuming, for example, that you're seeking a remedy such as habeas corpus, and of course, in that particular case, habeas corpus is not among the powers identified under Section 13B of the Judiciary Act. It's not one of the powers under Section 75(5) of the Constitution. Mandamus, remember, habeas corpus, remember, is the power of the court to compel the executive to explain the lawfulness of its detention of a particular person, or why it may be limiting the freedom of a particular person. So that is a writ issued by the court. That is not found in Section 39B of the Judiciary Act, neither is it in Section 75(5) of the Australian Commonwealth Constitution. The power as well of declaration, the power of the court to say that these are the rights of an applicant. Again, they're not in Section 39B, so they're part of the common law. Okay, so in these particular cases, even without resorting to Section 39B of the Judiciary Act or Section 75(5) of the Constitution, we need to bear in mind that the courts have a common law jurisdiction to issue these particular remedies, habeas corpus, for example, or declaration. Okay, so we're clear. We've made the distinction there. Justiciability of the dispute. This particular element. So again, going back to jurisdiction, be clear that you have to be clear what exactly is the basis for the jurisdiction of the court in order for it to exercise its power of judicial review. So that's number one. Now, secondly, going to the issue of justiciability of the dispute, there are two aspects of this, but they're not going to be relevant to the final examination. But just as a refresher, there are two aspects to justiciability of the dispute. One is that under the framework of Australian constitutional law, courts can only have jurisdiction when there is a matter before it. So if you look at the formulation of Section 75(5), it says that the High Court has jurisdiction in a matter. Okay, so there has to be a matter, and a matter is any actual controversy involving, the violation or the infringement of a right, a legitimate expectation of a person or an individual or a corporation. But there has to be an actual controversy, and of course, what it means, therefore, is that if an individual, has certain rights that have been violated by an act of the executive, then there is a controversy there. There will have to be an actual controversy involving the rights of that individual. So that's justiciability number one. It involves a matter, an actual controversy. The second aspect of justiciability is that courts will only, even if there is a matter, therefore, even if there is a matter, there's an actual controversy involving violation of a right or liberty or property of an individual or of a corporation, courts will not accept jurisdiction or will refrain from exercising its jurisdiction if it involves a political question, or what might be called a non-justiciable issue. Because when you speak of a political question, what it essentially means is that courts have difficulty trying to apply legal standards. If it's a political question, what is the legal standard there? The courts will say, that is something that is best left to the elected representatives of the government to make a decision on. So when it's a political matter, so for example, should we go to war? Should a treaty be entered into? These are political questions. Should taxes, amounting, what if the Commonwealth Parliament passes a law where the income tax would be 90% of the income of a person, which is really confiscatory? If you think about it, can you imagine if 90% of your income were to be subject to income taxes? And so therefore people complain, how can we live? But that would be an example of a political question. But because what exactly is the legal standard that will be applied by the court? So that is a political question. So that's the issue of justiciability. That will not be relevant in our final examination. The standing of the applicant, it means that there is that applicant has locus standi in law because he or she suffers based from the executive decision, because his right, legitimate expectation, or interest may be impaired or infringed by the actions of the executive. Now, grounds for judicial review. We know of several grounds for judicial review, right? But the focus of the final examination would be, are you seeing this particular slide now? Slide number 4 for assessment topics. For the purpose of the final examination, there will only be 4 grounds of judicial review that will be relevant. One is statutory purpose and relevant consideration. And in that particular case, our focus will be on the issue of the exercise of discretion. And I will speak a bit more about that in a short while. Second is natural justice. And in that case, the focus will be on the rule against bias. And I'll speak more about that in a short while. The third ground of judicial review is law, fact, and evidence, and then Wednesday and reasonableness. I'm going to go back to those in a short while. Okay, so we've talked about standing the applicant. The fourth element is grounds for judicial review, which I will discuss in greater detail in a short while. And then fifth, you need to be able to explain what the judicial review remedy sought is. This is also crucial because we recall, following the case of Green versus Daniels, where Justice Isaac said that even if the court were of the view that the actions of the executive actually impaired the rights of an individual or the rights of an applicant, because judicial review is meant to be limited and narrow, it means that, and it also means that the judiciary cannot substitute its own decision for that of the executive. So there is a limit to judicial review. Judicial review is not meant to be an appeal, and a process of appeal, but it's meant to provide a supervisory power over the executive, and so therefore it is limited. So the judiciary, in exercising its power of judicial review, number one, cannot substitute its own decisions for the executive. It cannot step into the shoes of the executive, and judicial review can only be based on questions of law or the legality of the executive, of the actions of the executive. It cannot look into factual questions. Judicial review cannot look into whether or not the factual determinations made by the executive were correct, because that would be going beyond the scope of judicial review. Okay, so these are the 5 judicial review elements. I'd like to emphasize in the meantime that when you do the final examination, for example, do not dwell too much on having to justify that the dispute is justiciable, because that's not really the legal issue. Of course, we know the dispute has to be justiciable, but you don't have to discuss it because it's not relevant. It is not really a legal issue in the course of the final examination. I won't be asking about that, so you don't have to discuss that. You can just say, we assume that there's an actual controversy, therefore it's justiciable. That's fine, that's it. And then the applicant has certain rights, legitimate expectations or interests that are breached. Therefore, he has standing. That's it. Don't extensively discuss the rules, because your focus will be, when you answer the final examination questions, your focus will be on 3 things. Okay. So the first will be talking about jurisdiction. That's the first one. The second will be grounds for judicial review. That's the focus. And the third would be the judicial review remedy that you're seeking. So those are the 3 you should be, providing an extensive discussion of. Okay. So we're good, we're clear. Any questions so far before I continue? We're good? Okay, let's proceed. So, in relation, therefore, to the assessment topics, okay, so let's clarify the assessment topics now. As I said, you need to talk about the jurisdiction of the court. You cannot speak of judicial review without saying what the basis of the jurisdiction of the court is in relation to the exercise of its power of judicial review. You have to be clear about that, okay? So if you're saying that the basis of judicial review is the ADJR Act, then you need to be able to show that the executive decision was based on an enactment or a law passed by the Commonwealth Parliament. If the executive decision was based on the exercise of implied powers of the executive or prerogative powers of the executive, you have at least 2 options: Section 39B of the Judicial Act of 1903 or Section 75(5) of the Australian Commonwealth Constitution pertaining to the constitutional writs of the High Court. And of course, we said the third would be the common law, because as we said, if you talk about habeas corpus, for example, you talk about the judicial review remedy of declaration. These are remedies found in Section 39B of the Judicial Act, nor is it found in Section 75.5 of the Australian Commonwealth Constitution, but they exist in the common law. You will not have to talk about the common law in the final examination. It's not going to be, there won't be a remedy about declaration, neither is there a remedy about habeas corpus. They won't be there. The focus, on the other hand, will be prohibition and injunction, as far as the judicial review remedies are concerned. Now, when I talk about prohibition and injunction, okay, these are terminologies found in the context of Section 39B of the Judiciary Act and Section 75.5 of the Australian Commonwealth Constitution, and of course, in the common law. Okay, so these are the writs which have been clearly identified based on Section 39B. Remember that, the power of the Federal Court of Australia to issue writs of mandamus, prohibition, or an injunction against an officer of the Commonwealth. Same thing with the Section 75.5 of the Australian Commonwealth Constitution, the power of the High Court to issue writs of mandamus, prohibition, or an injunction against an officer of the Commonwealth. Now, remember, as I said, prohibition and injunction are writs of the court under the common law as well, but they have been subsumed under Section 39B of the Judiciary Act, as well as Section 75.5 of the Australian Commonwealth Constitution. When you examine, however, the ADJR Act, you will notice that it doesn't use the word prohibition. The ADJR Act also doesn't use the word injunction, which means, therefore, that if you are saying that the basis of the jurisdiction of a court is the ADJR Act, you should be using the exact language under the ADJR Act. And under the ADJR Act, it will say that the court has the power to restrain the executive from acting in a particular way. So you have to make sure that if you're relying on the ADJR Act as the basis for the exercise of the jurisdiction of the court, do not use the word prohibition nor injunction. You have to use the word under the ADJR Act. Okay. Now, let me just say a few more. Say a little bit more about prohibition and injunction. The thing about prohibition is that if you were to rely on the common law, what it would typically mean is that the writ of prohibition will only be issued by a court when a decision is made by the executive acting judicially. Okay, so it is acting judicially, meaning it's acting like a court. So it's acting like a tribunal. Then you can issue a writ of prohibition. But more importantly, it also means that the writ of prohibition will only be issued, for example, when, among grounds like the decision was in breach of the rules of natural justice. So there are particular grounds that have to be identified under the common law. If you rely on the ADJR Act, there is no such restriction because, number one, if you rely on the ADJR Act, your goal, what exactly is the writ of prohibition? The writ of prohibition essentially stops the executive from enforcing its decision. It's almost about quashing the decision of the executive. That's the nature of a prohibition. It quashes the decision of the executive. And because the decision is quashed, because remember, that's when you look at the power of judicial review, at its core, the power of judicial review is to quash an executive decision. Because if an executive decision has been quashed, it means it will no longer have a legal effect. Correct? Now, it doesn't mean that it will necessarily, give you certain rights. It will not give you certain benefits, as pointed out in the case of Green versus Daniels, but at least it puts a stop to, the ability of the executive to enforce its decision. So, for example, if there's an attempt on the part of the Commission of Taxation to try to seize your goods or your property, and the courts issue a writ of prohibition, it will mean that the Commission of Taxation can no longer enforce its decision to seize your goods. if a writ of prohibition is issued by a court, it might mean that the immigration can no longer deport somebody. It can also mean that it can stop an investigation and so on. So the nature of a prohibition is actually kind of the quashal of the final quashal of an executive decision. Injunction is different, especially because at its core, injunction, if you look at it as an equitable remedy, is actually an attempt not just to control executive decisions, but actually to control actions that might violate the law when there is potential damage or harm to the substantial interest of a person, and there is, in the balance of probabilities, would be to favor the certain action from being enforced. So the advantage of injunction, therefore, is that one, it doesn't have to, the injunction does not have to relate to a final order. The injunction can be preliminary. So it could be a writ of preliminary prohibitory injunction to stop or restrain, for example, an executive from continuing with these actions. If you deal with a prohibition, it means that you have to wait for an order, for a final decision to have come out, because you cannot have a writ of prohibition to be issued without a final order coming out. An injunction, however, is that even if there is no final executive order, you can already seek the executive to be restrained from proceeding with its intended actions. There are two aspects of the injunction. One is a writ of preliminary prohibitory injunction. You can also have a writ of permanent. You can also have a permanent writ of injunction to permanently enjoin the executive. You can also have a writ of mandatory injunction to compel the executive to act in a particular way. The mandatory injunction, I think, will not be assessed, but these two writs, prohibition and injunction, will be relevant for the final examination. But as I said, be mindful that if you rely on the ADJR Act, you shouldn't be using the words asking for the issuance of writ of prohibition or mandamus or injunction, because these are not terminologies under the ADJR Act. You'll ask you will probably say that you will ask the court to quash the executive decision, or you will ask the court to restrain the executive, or you'll ask the court to order the executive to do this or to do that, using the terminology under the ADJR Act. Okay, clear so far? Any questions? So we're good. So those are the two remedies, I think, that are relevant for the final examination. So we've covered that. Grounds of judicial review. Statutory purpose and relevant consideration. We're just focusing on the issue of discretion. If you recall the topic on statutory purpose and relevant consideration, what it means is that, as we said, although the executive has certain implied powers, what it also means is that if you recall about the rule on legality, if you recall the rule about legality, the rule about legality says that if the executive acts in a way that will impair or infringe upon the rights of an individual, you need a positive law for that. Positive law means that it is a law coming from the Commonwealth Parliament. So the executive, for example, on its own does not have the power to just seize the goods of anyone. It doesn't have the power to just enter the house of anyone. It doesn't have the power to just eavesdrop on communications, because that infringes on the rights and liberties and freedoms and properties of individuals. Based on the principle of legality, if the executive acts in a way that impairs the rights or property of an individual, they need positive law for that. Positive law means it must come from the Commonwealth Parliament. Now, it means, therefore, that if there is a power given to the executive that might impair or infringe the rights or legitimate expectations or property or interest of an individual based on a law passed by the Commonwealth Parliament, what it means is that the executive must act according to the law. It must act according to positive law. It must act according to what the enactment or the statute provides. The statute, in general, will have a statutory purpose. There's the purpose of the statute, and it might also talk about what considerations need to be taken into account by the executive. So we're talking of it in general. But for the purpose of the examination, I am looking at the issue of the exercise of discretion by the executive. I don't want to discuss this any further because I might end up providing the answer. But what I'd like you to think about is this particular question. What if a law says that the executive can act in any manner that he or she deems fit, or can use his discretion, as he sees fit? Absolute discretion. What does it mean? Does it mean then that the powers of the executive are unlimited? That there are no constraints? Does it mean that the executive can act irrationally? Does it mean that the evidence that the executive can act even if the decision is not based on evidence? So that is a question I'd like you to think about, the exercise of discretion for the purpose of the final exam. And so I don't want to say more about that, but the focus of, so from Gary, it must act within the intent of the act. Okay, yeah, so that's essentially the rule there, okay? So as Gary pointed out, even if there is, the phraseology is absolute discretion of the executive must still act according to the law, according to the statutory purpose, must still act according to the intent of the law. So it's not really unlimited. And the executive cannot disregard the rules of evidence. The executive cannot act irrationally. In other words, when you speak about being irrational or what might be considered to be Wednesday reasonableness, it means that the executive must still act according to reason, okay? And we're going to talk about Wednesday reasonableness in a short while. So we've covered the topic on statutory purpose and relevant considerations. In that case, we're looking at the issue of exercise of executive discretion, okay? Discuss that. I can't go into further detail. Secondly, the other ground of judicial review that will be assessed is about the rule of natural justice. There are two aspects of the rule of natural justice. One is the principle that before the executive makes a decision that affects or impairs the rights or interests or legitimate expectations of an individual, the individual must be given an opportunity to be heard, what we call the prior hearing rule. We assess that during the midterm assessment. The focus for the final assessment will be the rule against bias. So the other aspect of natural justice is that the person, the executive, making a decision that affects the rights of an individual must be objective, must be free, and must be free of bias. Okay, because otherwise, if you have an executive making a decision, meaning that person is acting in the form of a judge, acting judicially, we would assume that judges are impartial. So they can't act like favorites. They can't act as judges if they have an interest in the case before them. That would violate the rule against bias, because we want a judge who is impartial, who is free from favoritism, who is free from enmity as well towards any of the litigants. So the rule against bias. But what exactly does the rule against bias mean? That's the question there. So, and I need you to have a look at the tutorial we had on natural justice, because I discussed this and it's in the discussion questions as well. Essentially focusing on if the executive, for example, says certain things, especially if the executive is a minister who is actually therefore a political animal, a political individual who has to articulate national policies. And the executive, especially the minister, makes statements that appear to favor a particular train of thought, a particular view. So there is a bias, apparently, on the part of the minister about a course of action to be taken. Does it mean, therefore, that that executive should no longer be able to, make a decision because that minister appears to be biased. What exactly does bias mean in that particular case? So I'd like you to examine that. That will be the other one. Law, fact, and evidence. The particular topic here again is that what we need to recall is that judicial review is it's limited and narrow. Judicial review is never meant to correct factual errors, no matter how grossly erroneous they might be. Even if the decision of the executive is based on a patently wrong determination on the basis of the facts, which means it leads to injustice, courts cannot intervene because courts only have a supervisory role. Courts still cannot intervene because otherwise, if courts were to intervene because of a factual error, it will essentially be already trying to assert a power over the executive to control even factual determinations by the executive. But the courts, in the case of Quinn versus New South Wales Commissioner of Police, pointed out that the role of the courts is supervisory, and courts will not intervene. We're going to go back to Westbury and reasonableness in a short while. And courts will not intervene to correct a factual error, even if the factual error leads to gross injustice to an individual. So we're clear? We're clear about that. Now, the only time when courts appear to examine the merits of the decision, therefore, is when there is no evidence to back up a decision. So when there is no evidence, we're not saying, so if there's a distinction, therefore, between no evidence and lack of evidence or insufficiency of evidence. The only time when there can be a ground for judicial review on the basis of evidence, it will be when there is no evidence to support a decision of the executive. Okay, so we're clear. So moving on, that will essentially be that will essentially come out in one of the final examination questions. Now, finally, it's raining here as well. Are you able to hear me? Because it's raining right now. I hope you could. Anyway, the fourth aspect, which is the issue raised here by Sullivan, is the issue of Wensbury and reasonableness. Wensbury and reasonableness is not just about the evidence. It's about whether or not the decision of the executive is such that no reasonable authority could arrive at a decision. In other words, there might be evidence to support a decision. There probably is evidence to support a decision, but even if there is evidence to support a decision, the question is, the decision that was made by the executive, is it such that no reasonable authority could arrive at a decision? So what it essentially means is that if reasonable minds could disagree on what the decision should be on the basis of available evidence, and there is evidence, but based on the evidence, for example, let's assume that there is evidence that somebody stole, that an employee of the public service stole a stapler. So there is theft of a stapler. There is evidence. What if the law, the Public Service, is that the Public Service Act or something, provides that in the event of theft committed by a public employee, there could be a penalty of between, from censure to termination, okay? And what if the decision is to terminate the services of that individual? So there is evidence, but the decision is termination. So in that case, it's possible that if the value of the stapler is $1, and then you terminate the services of the individual on the basis of the theft of $1, it might be possible that that becomes a very oppressive, too oppressive a penalty. And because of that, it may amount to what is known as Wensbury unreasonableness, because no reasonable authority will probably terminate the services of an individual simply because that individual stole a $1 stapler. From Gary, ignorance of relevant fact, no right of judicial review. Okay. I think Gary, this particular case is talking about law, fact, and evidence. Okay, so okay, so let's just address. Okay, I'm going to go back to that, Gary, so I don't get sidetracked. I'll go back to your relevant point, but let me just focus on Wednesday and reasonableness here, and then I'll go back to the point made by Gary. What is important to remember is that when it comes to Wednesbury and reasonableness, in general, courts seldom will exercise their power of judicial review on the ground of Wednesbury and reasonableness. Very seldom, because the rule is it will the judicial review to consider a decision of the executive to be unlawful according to the law on the ground of Wednesbury and reasonableness will only happen when there is no reasonable authority, that no reasonable authority could arrive at the decision. So if there is a possibility of disagreement among reasonable authority or officers, there can be no Wednesbury and reasonableness. So for example, if somebody stole a stapler worth $1, and the decision was to impose suspension of, let's say, 30 days, in that particular case, it is possible, it is reasonable for reasonable minds, for reasonable persons of authority to argue that, to disagree that, 30 days is reasonable. It is based on, there is reason behind it, okay? From Gary, I think that value has a relevance. It's the act unto contrary to actions in breach of non-policy and conditions. Okay, in this particular case, I think Gary is not referring to Wednesbury and reasonableness. It's probably referring to relevant consideration, law, fact, but we're going to go back to that, Gary, but thank you for raising that. Okay, are we clear about Wednesbury and reasonableness now? Any questions so far? We're clear. Now, let's talk about the point raised here by Gary about ignorance of relevant fact. This is not going to appear, I think, in the final examination. It might be. Okay, the basic rule is that the executive is not required to canvass or to go through all relevant considerations before it makes a decision. So let's assume that the executive has to make a decision whether or not to hire somebody, or the executive to make a decision to grant funding, or to fire somebody, or whether or not a visa application should be granted. There are many possible considerations you need to take into account, like who the person is, what the activities of the person are, how much money that person has, etc. There are many possible considerations that could be considered by the executive in arriving at a decision. But there is no requirement for the executive to consider all possible relevant considerations. The only time where the consider is required to consider certain relevant considerations is when it is required by law. So it is certainly up to the executive to ignore certain considerations. The only time the executive will be required to consider certain considerations, or certain factors, you might say, is when it would be required by the law. Okay, so we've covered the assessment topics. I won't also be assessing the Freedom of Information Act of 1982. Any questions before we continue? So we've covered the assessment topics. We good? Okay. So moving on, let me just give some guidelines now on how to do well in the exams. So, but let's start with the assessment type. There will be 4 problem-based questions. The final examination is meant to be completed within 2 to 3 hours during the 24-hour period. You should only be devoting between 2 to 3 hours and not more than that. If you're spending 5 hours, you're overdoing it. Okay, but it also means you need to sit down, and you need to sit down to focus exclusively on the exam. but you're meant to just complete it within 2 to 3 hours. There is a maximum word count limit, which is 2,000. Try to aim to be direct to the point and concise in your answers. There is no requirement for footnotes or a bibliography. So there is no requirement for footnotes or a bibliography, but reference when you can. The point being that if you could really identify, the case law you're citing, identify the statutory provision you're citing, but you do not have to use footnotes. But they have to be in your answer. They have to be in the paper. Are we clear? So you do not have to follow the AGLC, but I need to see the basis for your answers. Okay? Yes, Nicholas.
Just a quick question in regards to that. Do you want AGLC referencing, or can we get away with in-text referencing, or would you
in-text referencing is fine.
Either or?
Yeah, I mean, if you want to do the AGLC, that's even better. But it's not important for the final examinations, given the limited time that you have. So if you were to do a final examination, invigilated exam, I don't think it'll be reasonable to expect proper footnotes according to the AGLC. So in-text referencing is fine. From Bridget, do we reference in the text? Definitely, you need to. You need to provide references for your answers. If you're saying this is what the law says, you need to tell me, is it based on case law? Tell me what the case is. If it's based on statute or if it's based on the Constitution, you need to be very clear what the law is and what the provisions might be. From Bridget, can we use footnotes? You certainly can. You can certainly use footnotes. I would encourage that. The footnotes will be counted in the word count. The footnotes will be counted in the word count. In the same way that if you're using in-text referencing, following, for example, the APA, the American Psychological Association referencing, it will be part of the word. It will be part of the word count. So during the final examinations, I'm not bothered by the kind of system you use to reference a citation. The important thing is you reference, if you're citing case law or you're citing a statute. But you do not have to follow the AGLC, and certainly do not provide a bibliography. It will not help.
Manjo, it's Bronwyn. Can you hear me?
Yes, I could. Bron.
Can I just ask you, if you're taking something from a textbook, do you want us to reference to text or only your case law and things like that?
Okay. As a matter of practice, avoid using the textbook as a reference. Because the textbook is really weak.
Okay.
You're relying either on case law or on statutes.
Okay, thank you.
So you can use the textbook because the textbook will tell you what particular case should be cited. The textbook will also say this is the particular statutory provision you should be using. So in that case, just pick up the case law cited by the textbook, but don't reference the textbook. Cite a case law or cite the statutory provision.
Thank you.
Okay. Can I change my course assessment if I don't pass? I don't see any reason, Gary, why you wouldn't pass. You'll make it quite well. Okay. So proper formatting is required. 12 points font size. It sometimes happens that students submit papers where they're using 9 points in terms of font size, and I would need a magnifying lens to read answers with those very small font sizes. So please use 12 points font size so I could read your answers. Questions so far?
You have a font preference, Manjo, like Arial or Calvary or something?
Times New Roman, Arial will be fine. I just need it to be at least 12 points. Okay, wingdings, that'll be difficult to read, Travis. Okay, so let's move on. IRAC format. So the IRAC format is really very important in terms of answering case type problems. And as I said, the use of the IRAC format is very common, very popular among law schools, always, if you're dealing with a case law. Because if you were to appear as a lawyer and your client came to you, you need to be able to identify the legal issue. because you cannot provide a legal advice without knowing what the legal issue is in the first place. So the legal issue will assist you in arriving at a conclusion. Okay, we could probably narrow down. Are you able to see this particular slide, which is slide number 6? Are you able to see it? IREC format? You probably could.
Yes.
Very good.
Yes.
As far as the legal issue is concerned, there are 3 possible legal issues you need to think about. Number 1 is, what is the jurisdiction of the court? Okay, so in other words, you're asking, if you're considering an application for judicial review, what is the basis for the jurisdiction of the court? That's the first legal issue you need to consider. Okay, and I will explain, why the issue is relevant. 2, you need to find out what is the ground for judicial review. You need to be able to identify the ground for judicial review. And thirdly, again, as a requirement, you need to be able to identify the particular judicial review remedy that you are seeking. So identifying the legal issue is important, because if you identify the legal issue, you can then articulate and state what the relevant rules are. So Gary, you will not be assessed on the merits review. It's just purely about judicial review for the final assessment. So based on the legal issue, you then articulate the relevant rules. Relevant. The problem, therefore, is that if you do not identify the legal issue, the question is, what rules will you be citing? Remember, there are so many rules pertaining to administrative law. In other words, what will you be talking about? Right? In the midterm assessments, for example, some students ended up enumerating all the possible grounds for judicial review. That's not going to be helpful. Right? Focus on, when you identify the proper legal issue, you will then be able to articulate the relevant rules. So if the relevant, for example, let's talk about ground for judicial review. If the ground for judicial review, you think, if the legal issue is about, the fact that whether or not the executive has shown a bias that disqualifies the executive from making an executive decision, if that is the legal issue, then your job is to state and discuss the rule about against bias of the executive. And even when you talk about the rule against bias, it has to be very specific, because there are at least 5 ways by which an executive might be disqualified from acting judicially on the ground of bias. What particular rule against bias are you speaking of? So you have to be very specific there. So so when you speak of the legal issue, you're probably saying the first legal issue here is whether or not the executive is disqualified from rendering a decision because of the rule against bias. In particular, the rule that the executive must not adhere to a particular a view that is incapable of being changed. So in that case, can you see how specific the legal issue is? If that is the legal issue that you've identified, then you articulate the rule. You explain that. Next. From Gary, benefit to consult these discussion questions, informing an answer. You're talking of the discussion questions and the answers I gave, I think. Yes, it will be helpful for you to have a look at my model answers. I just wish to emphasize that the answers I gave to the discussion questions were never meant to be extensive. They were just meant to tell you what the correct answer is. So I leave it up to you to provide a more exhaustive answer. So that's one. So we talked about ground for judicial review. Identify the particular legal issue. It cannot be broad. So once you've identified what the legal issue is, then you articulate, then you identify, then you discuss the relevant legal rule. It cannot be open-ended. So you cannot be talking about all sorts of grounds for judicial review which have nothing to do with the facts. You know what I mean? If it's about natural justice, the discussion about the rules should just be natural justice. Particularly, for example, bias. Don't talk about, the prior hearing rule. What's that for? That's nothing, it's irrelevant, okay? It adds no value. In fact, it will diminish the quality of your answer, because it means you probably don't know what you're talking about. Because why are you talking about the rule about the prior hearing rule? That's nothing to do with the facts. Okay, so that's one. Let's talk about jurisdiction of the court. We again said that as far as the jurisdiction of the court is concerned, it's past 8:10. If you have to go, feel free to do so. For those of you who might be hungry, or you need to do something else, you need to be clear about the jurisdiction. If you think that is if the relevant question is, does the court have the power to exercise judicial review on the basis of the ADJR Act? That's the legal issue you framed. Discuss that in the rule. Then don't talk about Section 39B of the Judicial Act. Don't talk about common law judicial review. Focus on the ADJR Act. Correct? Now, if the executive decision is based on the exercise of implied powers of the executive, then you probably will say the legal issue here is whether or not there can be judicial review on the ground of the exercise of implied powers of the executive. That's the legal issue. The rule then will be that under the law, when the executive exercises its implied powers, judicial review is still available. Judicial review is available under, for example, Section 39B of the Judicial Act of 1903. So you're not talking about the rule. Under Section 39B of the Judicial Act of 1903, the Federal Court of Australia has the power to issue writs of mandamus, revision, injunction against an officer of the Commonwealth. So we're clear? Can you see the advantage of identifying the legal issue? So in that case, if you're talking about the implied powers of the executive, do not talk about common law judicial review. Focus on Section 39B of the Judiciary Act. And don't talk about the ADJR Act. You can, but quickly say, the ADJR Act is only available when the executive decision is based on an enactment. Because this is not based on an enactment, but based on the exercise of implied powers of the executive, the ADJR Act is inapplicable. We're clear? So that's the rule. So the beauty about identifying the legal issue is it will lead you to identify the relevant rules. So rules that have nothing to do with the legal issue are irrelevant and will diminish the quality of your answer. It means you don't know what you're talking about, okay? So if you've identified the legal issue, you will know what rule to discuss, and then you apply the rules to the facts. See, if you have facts, for you to arrive at a conclusion or at a decision, you need to know what the relevant rules are that need to be applied to the facts. Remember, you can only apply the rules if you know what the legal issue is. So the legal issue will tell you the rules. Once you've identified the legal issue, you apply them to the facts. The application of the rules to the facts means that you need to be able to make an argument. Even if you have the rules, when you apply the rules to the facts, you can come up with different conclusions. You can say that the rule says that, for example, it's about widespread reasonableness. The rule is that when a decision will amount to widespread reasonableness if no reasonable authority will arrive at that decision. So that's the rule. Applying the rule to the facts, for example, it shows that it's possible for executives to disagree about the particular decision, and because of that, under the facts, the decision of the executive does not amount to widespread reasonableness. So the application, therefore, that's where you make an argument as to that will then lead you to a particular conclusion. From Gary, will the questions reflect if decisions are based on enactments or not? Yes. When you look at the way that I frame the questions, they're very specific. You will know if the decisions are based on an enactment or they're based on the implied powers of the executive. So in times past, I would not be clear just for the purpose of testing students' understandings, and I would leave it to the students to supply the facts, like in a scenario 1, scenario 2. But I made it very simple in the final examination question. That if the decision is based on enactment, you will see it there. If it's based on the implied powers of the executive, it will be apparent to you. So when you apply the rules to the facts, it will then lead you to make a conclusion, right? So that's the beauty of it. If you follow the IRAC format. If you don't follow the IRAC format, I don't know how you're going to do it. You're going to talk about the rules straight away, but what rule will you be talking of? So that's the importance of the IRAC format. So we're clear. So we're moving on. We're very close. So suggestions in answering case problems: follow the IRAC format or the SIRAC format. The SIRAC format simply is that you begin with the conclusion, short conclusion, and then the IRAC format. So SIRAC format, state with the initial conclusion, and then indicate what the issue is. Make sure to properly and thoroughly identify the legal issues. State the rule. So state and explain the relevant rules and legal principles. So explain key concepts, whether they're natural justice, ransomware reasonableness, and so on. Do not just drop the names of cases without explaining what it is you are trying to establish. So if you cite a particular case, explain what the relevance is of that particular case. Because remember, this is an open books examination. So if you just, I've seen students enumerate cases which had nothing to do with the legal issue. So if you're going to use a case, make sure that you're paraphrasing the decision of the court, because when you say paraphrasing, you're using your own words. What you're doing in paraphrasing is that you're using a court decision to argue a particular conclusion. So that's what you're doing. You're using the rule to make an argument. Because remember, when you look at the decision, a decision of the court, it can be used in various ways. But what you're trying to say is that I am making this assertion on the basis of this court decision. That's what it's all about. Okay, so it is insufficient for you to just cite a case. You're actually using a case law in order to make an argument. From Gary with a question. Okay, we've done that. So there is no mark for excellently stating legal principles or cases that are irrelevant. So if you, what you call do a brain dump, you're just citing a lot of cases and principles there, which have nothing to do with a legal issue, there is no point for that. In fact, your answers will be diminished. So, and then application, apply the rules to the facts. Conclusion, state your final conclusion. You can end your answer with force of phrases such as in conclusion or hence. So that's the way to come up with a conclusion. Okay, so finally, last technique. Your job is to tell me what you know. You will be marked based only on what is written. So I cannot, I cannot divine what's in your mind. So I will only be marking on the basis of what is in what is written in your answers. I'm doing all the marking, but there won't be any marker for the final examination. You also try to write in a way that you can be understood. So don't avoid forcing me to try to figure out what it is you're trying to say. So, if you're going to be a good lawyer, you need to be intelligible, easy to understand, especially, whether judges or by a client, you need to be understood, okay? Avoid a brain dump. That's when you're just, putting information in the answer that are totally irrelevant. So don't do that, because this is an open books examination. So I won't be impressed if you just, you have so much information there which add little value. There is also no mark for just copying or pasting text from other sources, which again don't have any value. Make sure to paraphrase. So if you're dealing with case law, don't cite long sentences or single paragraph from a court decision. You need to paraphrase. You need to use your own words, because if you give me a long passage consisting, for example, of 5 sentences from a court decision, then I'm trying to say, so what are you saying here? It's too long. If you paraphrase, you're essentially saying, this is the law. So you're pointing to me, what the relevant rule is, okay? So paraphrase. At the same time, avoid plagiarism. There are two aspects to plagiarism. One is, at its core, when you make a statement that is important and you don't provide a reference, you're actually committing plagiarism, because you're saying that those statements, those ideas are your original ideas. Now, if they're not your original ideas, they came from somewhere, you need to provide a source, because that is plagiarism. Okay? How else is plagiarism done? So that's, yeah, okay. Now, plagiarism will easily capture that. If you do that at the same time, the other thing about plagiarism is, the use of quotation marks, okay? So if you're trying to lift a passage from a court decision, for example, you need to use quotation marks, because the quotation marks, open and close quotation marks, will signal to us that you're quoting from a particular source, okay? If you don't, you're actually asserting that they are your statement. So in other words, the thing about plagiarism is that even if you say that, this is a court decision, and then you're lifting verbatim statements coming from a court decision, but you do not use quotation marks, you're saying that those are your own words. You're still committing plagiarism, not because you failed to cite, because you did, but because you did not use quotation marks. You're actually making it appear that those are your own words, but they get picked up by Turnitin. So that's the second aspect of plagiarism. Okay, so avoid that. So the only time you don't use you don't use quotation marks is if you're using your own words. You're paraphrasing. So when you paraphrase, you're no longer saying, you're no longer lifting verbatim certain words and then provide the reference. Because otherwise, plagiarism would be of at least two kinds. You fail to reference an idea that is not yours, and two, you're claiming an idea, the words to be yours, even if you cite a particular reference. And then use connected prose and coherent sentences in your answers, because sometimes, I've seen some students where there's a sentence, there's another sentence, but they're incoherent. You should be writing in paragraphs. A paragraph is composed of sentences that talk about just one common theme. They have a central thesis. Okay, they have a central idea. That's what a paragraph is all about. So what if you have sentences that talk about this idea, now that sentence talks about here, it's kind of disjointed. It's like, what are you talking about? Okay, so try to talk in a paragraph. So a paragraph would usually have a thesis or a central idea, just one central idea. Avoid answers that mainly use bullet points, in fact. So avoid answers. Should be writing in full sentences and in full paragraphs. And then finally, review your work for grammar, spelling, punctuation, formatting, etc. I need to emphasize this because sometimes you think, it's just a spelling error, it's just a punctuation error, it's just a formatting error, it's just a small grammatical error. But when you think about it, if you have a written work and it shows evidence of spelling errors, you would have to say that, oh, okay, this person is being careless in spelling, being careless in punctuation. But the problem is, if this student is careless about spelling and careless about punctuation, careless about formatting, how careless could the student be in relation to the ideas, right? Right? So it doesn't make sense. And, the spelling and punctuation are pretty evident. So, I don't know. There are a lot of free software, I think, which you could use, which will signal to you, spelling and punctuation and formatting errors. I easily spot them. That's my problem there. And, that's a spelling error and so on. So try to just review, but at the end of the day, yeah, Grammarly is pretty helpful. So try to review that, because I go back to Dennis Denuto. Good luck, everyone. Okay. Oh, who's Dennis Denuto? Is that another lecturer? Okay. So that's it. That's the end of the tutorial session. And so before I end tonight's session, again, I want to thank everyone for always being there, for being very engaging. I did encounter a student who caused me problems. Thank God for this term. Can be, can give a headache when you've got a student who's been complaining. Thankfully, I've had a very great time, surprisingly, this term. Even if there are more than 100 students, no one has been really complaining, at least to my face. I don't know if, there's something I don't know about, but I'm very thankful for the quality of students I'm getting so far. So
Manjo, can I say something? It's Bronwyn.
Yeah.
I've come from another university, and I'd just like to say that the way in which you've provided us with instruction, guidance every week, and the resource material that you've provided, all I can say is look out, government, because we'll be highly skilled in terms of contesting their decisions. So but I've really, it was something that seemed very daunting at the beginning with all of the different rules and the way that the different things are applied.
Yeah.
But certainly you've provided a lot of clarity, and I'm certainly happy to say, and I said it in my evaluation, I think you're one of the strongest points in the information that you provided that make this course incredible. So really, thank you very much. You haven't had any complaints because, look, I come from a long background of law, and lawyers say lawyers practice and lawyers that can't do it teach, but you certainly have proven different. So thank you very much. Thank you.
Brother. And I will take good note of what you've said. Really, thank you.
No, thank you.
Thank you. Can he cook? Oh, I can cook really well, Gary. Thank you, Macy. Thank you. Okay, anything else before we go?
Just one final question or comment.
Yes.
Since we're limited to 2,000 words and there's 4 questions, and we're looking at the IRAC function, I would imagine, based on everything you've said tonight, it would be pretty hard not to come up with a confined answer within about 500 words for each question. So if you're just doing a brain dump, if you're going anywhere over 500 words, you're way off track. That would just be my comment.
That's right. Yeah. I mean, a good lawyer is one who can articulate key thoughts in a concise manner. Right? Okay. So thank you as well, Wendy. And so that's it. Jackson, Sarah Rogers, Nicholas, you've always been there. Sarah Goodchild, thank you. Mercy, you've always been there. Gary, who else? Keith, always there. So thank you. And thank you as well, Travis, for always being there. Mary and Lauren and the others, Mo, the others, Mike, Tamara, Saturday. So the others I can, I may have failed to acknowledge. Thank you so much. I truly enjoyed teaching this unit. So I will miss you, all of you guys. And enjoy, taking the final examination. Jackson, our actor disguising as a student. Yeah, okay. So have a great time. Enjoy doing the final examination, okay? And so I'll see you soon. Yeah, Ryan Gosling. Yeah. Okay. Thank you. Okay, Nancy, see you soon. Bye.